Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is Attorney Kenneth J. Landau with the Mineola law firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, Attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. We have a special program today about commercial mediation or arbitration. And mediation or arbitration are forms of ADR, which means alternate dispute resolution. My special guests are Elan Weinreb, and he's an attorney with his own law firm in Garden City, and also Gary Fishberg, who's with the firm of Cullen and Dykman with offices in Garden City as well. And they're very involved with the mediation arbitration program of the Bar Association Nassau County, especially in commercial disputes. Welcome to Law You Should Know. I realize that ADR and mediation arbitration are used to resolve many disputes, matrimonial, torts, elder law disputes, but I'd like to focus on commercial disputes, how can be used successfully to resolve commercial disputes, both large and small. And Elan, why is mediation and arbitration so important to resolving commercial disputes?
Well, Ken, thank you very much for both having Gary and myself on the show today. ADR is extraordinarily important for resolving commercial disputes in that it principally provides a mechanism for getting out of court and avoiding the litigation process. And in that view, ADR really allows people to save a ton of money. That's its primary advantage, also saving time and as well as aggravation in many different contexts, but in particularly the commercial context when you're dealing with disputes of any type, whether it's small claims types of disputes or even the higher end million or billion dollar disputes, you have the ability to short circuit up to 90%. Maybe even more of the transaction costs and the attorney's fees and all the aggravation that goes into litigation.
Right. So I'm involved in torts a lot, and sometimes we resolve it through mediation or arbitration on behalf of plaintiffs or insurance carriers. So it's going to save the legal expenses to both sides. In a commercial matter, a firm or individual may be paying attorneys. It's going to speed up the process. It's going to perhaps give them more control over the result, and it's going to allow them to schedule it at a mutually convenient time and decision maker, which all will not happen under the traditional litigation process.
That's correct. All of those are the cardinal advantages of ADR in both of the processes. And
in particular, in mediation, it allows the parties to resolve their disputes and allows them to fashion a result that they may not be able to get from a judge.
And they have no control what a judge decides, good or bad or neither.
Correct.
But mediation, they have to sign off and accept the resolution.
They do. It's not binding, but if the parties can fashion their own result, and there's sometimes very unique ways to end a lawsuit without one person being an absolute winner and one person being an absolute loser.
And usually with the help of a skilled, experienced mediator who may or may not be an attorney. In many cases, they are.
That's correct.
Okay. And Elan, in an arbitration, a lawyer or the arbitrator or a panel of arbitrators will make a decision that will become binding or not on the parties.
Yeah. The decision in itself is called an award, and very often the providers of ADR services, arbitration providers, have their own rules regarding the provision of the award when it has to be issued. But to answer your question, there is a final decision, and that's in the form of the award.
And mediation, if it's successful, it's not binding on the people showing up. But once they agree to a resolution, it may become binding on them. And the outcome is the same. They'll save a lot of time, money, aggravation, and especially legal fees.
Correct.
And they might, with a mediation, they'll get a decision, they can live with it. They might not love it, but they can live with it. With litigation, they both may hate the decision.
I just want to correct one
Sure.
point. In terms of mediation, we really don't reach a decision. We have a decision comes from the word to actually cut something into two, as like incisors that you have on teeth. Decisions aren't really reached at mediation. Instead, what you have is more as resolutions.
Well, there's a everything. Well, I like to say ADR means all disputes resolved. But at the end of a successful tort mediation, both parties sign a statement what the terms of the resolution are.
That's fair and accurate.
That's what I mean. If it comes to that, and most of the time it does. So,
But the important
Yes.
thing is that the parties reach the agreement.
the parties have to okay it or
Right.
not. Absolutely.
The mediator does not impose an agreement. He's there to help the parties try to reach an agreement.
But again, he or she may suggest terms, may suggest compromises, may in some cases make recommendations. It's kind of what goes on in labor disputes and in baseball player or professional, athlete negotiations, where the mediator goes back and forth to both sides and talks to them and is creative at trying to fashion some dispute they can both live with.
Right. Well, that's actually one style of mediation
Okay.
where you have a type of shuttle diplomacy. But in terms of the process, there's many different styles. In fact, I'm actually working on a piece right now, which I just finished off the rough draft today, on something which I like to call chameleon mediation, which essentially is, or some people refer to as protean mediation, where essentially the mediator adopts a style which is based upon the disposition of the parties. So that in one place they'll be more evaluative, leading to a decision, like you were talking about, Ken, or in other places, like maybe much more facilitative, trying to have the parties interact with each other to let them themselves work out their differences.
Right. There may be different models that work for different disputes. Sometimes the one party or the other wants some kind of value or feedback from the mediator. Sometimes they can't talk to the other party and they want the mediator to do it. Sometimes there's a stumbling block. They've agreed on some issues or some terms, but they need their input on others.
Yeah, that's all correct.
So, and again, a mediator may have different styles, and they may work better for some disputes or some groups of people.
And
Gary,
we've had mediations where the mediation gets resolved because one party or other apologizes to the other party. Mm-hmm. And this is something that you can't do in court. They apologize, and the other party says, fine, with that apology, I'm going to take a small settlement, or I'm going to make this go away.
Or maybe there's something else, a change in conduct in the future, or some other terms, or non-economic terms. Who knows what? I mean, it could be about almost a different way of doing business or something going forward. So what about – but in both processes, both parties have to agree to that form of resolution. Sometimes it could be an arbitration agreement, and sometimes there may be some mediation process that people have to try to follow. But otherwise, both parties have to agree to it.
Well, in both cases, there's usually some form of written agreement. If the parties don't have a pre-existing written agreement, which is very often the case in mediations, then what will end up happening is that the parties will have either an attorney draft one up for them, or they'll arrive at it themselves, or they'll go to a provider which has a standard form agreement that is provided to them, and then they agree to those terms, and that becomes the agreement.
Right. So both parties agree on the provider, but even usually they agree on who the facilitator will be. You know, who the mediator or the arbitrator is, someone they both kind of trust or they feel will be objective and knowledgeable about that area of the dispute.
Yeah, they can do that themselves, or sometimes even the provider has a process. For example, the Nassau County Bar Association has a streamlined process involving selection of 5 mediators or arbitrators, depending upon which process is being used. And then that list of 5 mediators or arbitrators is presented to the parties.
And each person can knock off 2 or whatever.
Yeah, I mean, there's
right.
the complicated, but yes, that's the general idea.
And a lot of providers do that. Sometimes in tort cases, I just like to come up with a few names that I can live with or my client can live with and propose those to the other side. This way I have total control of the panel, so to speak, and that, if that works, because I have people I know are experienced in that area and have a track record of resolving disputes.
But also you have a situation where the commercial parts of the Supreme Courts in all the surrounding counties will actually send cases out for mediation. In fact, in New York County, they actually had a trial program where 1 out of 5 cases being filed in the commercial division were sent out to mediation with a mediator appointed by the ADR director, subject to the parties agreeing that person would be suitable.
Mm-hmm.
No, I agree. And if the person has the skills, the people skills, the legal background, the process skills, then it has a good chance of working in like 95% of the time.
Actually, there's some statistics on this. David Abeshouse, who's one of the mediators and arbitrators for the Nassau County Bar Association, ended up stating that in the realm of commercial mediation, more than 85% of mediated business cases result in settlement agreements.
And I would say that's true in torts, at least that percentage, in cases where the parties agree to mediate. And Gary, let me just ask you about when's the best time to propose mediation or perhaps arbitration? The beginning, the middle, or near the end?
It really depends on the flow of the case. There are some courts that will send mediation cases out right away. Sometimes the parties are prepared to go forward. Other times I find that the parties will say, we can't go forward because we need a certain amount of discovery. But the best time probably is to send it out early before you start having to spend money on discovery.
And I think also a skilled mediator or arbitrator might be able to fast track and help with the discovery process. Getting down to the real discovery that's needed, or reach a range of possibilities or rough information.
That's right. When I get a case assigned to me in mediation, one of the questions I ask the parties in a pre-mediation conference call is, have you got all the information that you need to deal with this case? And sometimes what happens is just what you described. Party will say, well, I haven't gotten everything. And the question would be, well, what are the things you need? What are the things that you very much need without going through the full extent of discovery? What do you need to evaluate this case and participate in the mediation?
Elan, do you have any thoughts on that?
Yeah, it's generally speaking, I 100% agree with Gary in terms of the timing. Getting out at the starting gate is certainly, by and large, the best time to either mediate or arbitrate a case, because the parties, aside from the fact that they haven't expended that much money yet, are not entrenched. And that's something you certainly have to worry about. But one thing also in terms of discovery, sometimes attorneys have this idea that they'll use mediation or arbitration, more mediation than arbitration in terms of the strategic concept, for using that as a mechanism or a way to obtain discovery. And it just should be known for those attorneys out there who are thinking that way. ADR processes, both mediation and arbitration, are not designed to do that. They're not a substitute for full-fledged discovery, and there's good reason for that. They're supposed to be more effective and cost-efficient.
And they also work best when the parties enter it in good faith with the intent of trying to resolve the dispute through ADR. We're going to take a short break for a moment. When we come back, we'll talk more about the process and what are some of the different stages that can take place at a mediation or perhaps an arbitration, and learn some additional tips from our panel today. Our guests are Gary Fishberg of the firm of Cullen and Dykman in Garden City, and also Elan Weinreb, who has his own firm in Garden City. We're talking about mediation or arbitration of commercial disputes, and you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, Long Island, New York. We'll be back in a moment.
The Employee Assistance Program at Nassau Community College is a voluntary and confidential assessment and referral program that provides services requested by employees. The program offers assistance with family-related problems, emotional or physical assistance, alcohol, and other drug-related problems. They also provide information on resources for childcare, elder care, and legal and financial support services. The program offers assessments, referrals, and a 24-hour, 7-day-a-week answering service. The Employee Assistance Program also has a professionally trained staff of licensed clinical social workers to help you. For more information, call the Employee Assistance Office at 516-571-7000. This message was brought to you by WHPC, the radio voice of Nassau Community College, now streaming at ncc.edu/WHPC.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is Attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. We're talking about commercial mediation or arbitration. And I think everyone, from what we've heard, mediation or arbitration can be used to resolve any type of dispute, matrimonial, tort, estate disputes, but we're focusing on commercial matters. But a lot of the discussion applies to any type of dispute. And as you've heard, it's a relatively quick way of resolving a dispute, finding a win-win outcome, saving a lot of attorney fees, and controlling some of the risk and exposure. So it works well. It helps mean all disputes resolved. Our guests are Elan Weinreb of the Weinreb Law Firm in Garden City and Gary Fishberg with the law firm of Cullen and Dykman, also in Garden City. And they're very involved with the commercial mediation and arbitration panel of the Bar Association in Nassau County. Elan, you just wanted to clarify what mediation and arbitration are for our listeners.
So Ken, since you have a lot of people listening to your show or just members of the general public and not attorneys, mediation, for those who may not be familiar with it, is a process where a neutral third party works with the parties, and that neutral third party is called a mediator, to reach a mutually agreeable resolution. And then that person works with the parties and their counsel to formulate a binding stipulation of settlement that may be filed with the court. And if a resolution or settlement is not reached, the mediator has no authority to impose one.
By contrast, in arbitration, the arbitrator hears evidence, receives testimony, much like a judge, but the extensive discovery proceedings are usually minimized. But in arbitration, the arbitrator does make a final and binding decision, which can be enforceable as a judgment.
Right. Arbitration can also, by agreement, be not binding, and the schedule is much more streamlined. Right. And the rules of evidence might be relaxed. So the parties, they can't mediate it, but they have an arbitrator or a panel of arbitrators they trust to render a decision that they'll might be binding on them and it will end the matter. It's still a cheaper way of resolving the dispute. And also they can agree on a high and a low, and a maximum amount of recovery, a minimal amount to avoid risk and tremendous exposure. Again, it's all subject to agreement. And we talked about some of the pros and cons. It could be done early on. It could be done after limited discovery. Let's say it's just before the mediation or perhaps the arbitration. Gary, what happens on the eve or in the weeks before the mediation or arbitration?
Well, normally when you get a mediation case assigned to you, the first thing we'll do is set up a conference call with the parties and establish some ground rules, try to get some flavor for what the case is about, try to get some understanding of what discovery may have occurred already, whether one party or the other needs some more discovery. And then we'll set a time frame to file pre-mediation statements. And normally I ask for statements that are short, no more than 10 pages. Try to lay out what each side thinks is their case. And I ask them to tell me confidentially. This statement is for my eyes only. I asked them to tell me what they think their strengths are, what their weaknesses are, and what their bottom line is in terms of a settlement number.
And correct me if I'm wrong, but a mediation submission from one party would only go to you, but in an arbitration submission it goes to the other side as well?
That's not necessarily always the way it works. You can have the parties – actually mediation between the two of them is often very more open than arbitration. Arbitration, you're correct. There are no ex parte communications. And what that means is that you can't have a communication with one party to the neutral, to the arbitrator or the arbitrator.
Every provider may have different rules, and the parties can always agree to modify those rules a little bit.
Right.
Okay.
And my choice is to have the pre-mediation statements to me for my eyes only, because I'm asking for information about what their bottom line is, what the strengths and weaknesses of their case are. But there's nothing that requires that. Some mediators will have the parties exchange pre-mediation statements, but some of that nitty-gritty stuff that I just spoke about will not be included.
Okay. And then, Ken, just very quickly to point out something that you sort of raised, you can actually have both. You could have a portion of the mediation statement, pre-mediation statement, bifurcated so that that portion is shared with both parties and another portion is confidential, mediator's eyes only, which is only given to the mediator.
Perfect. And so now we come to the event itself. So, it's done at everyone's convenience, unlike a trial. It's done at a mutually agreeable place, maybe a lawyer's office or a mediation provider's office. And Elan, you had a very clever mnemonic about the process that can occur. And then Gary will go to you for just telling our audience about the process and dynamics. And lastly, I would like you both to offer tips to the lawyers and the parties during a mediation and perhaps an arbitration. But give us your mnemonic.
Okay, so the mnemonic actually is not mine. It was given to me by Professor Leela Love of Cardozo, so there's a quick shout out to her. Okay. And if you think of the animal, the badger, right, that's the mnemonic, B-A-D-G-E-R, badger. Begin the discussion, assemble information, discuss needs and interests, generate options, escape to caucus. A caucus is a one-on-one meeting with the mediator. One side of the dispute meets with the mediator without the other side being present. And the R, the last letter, stands for resolve the dispute, meaning come to an agreement, not necessarily a settlement, but come to an agreement that can be used to go forward.
So, Gary, as I understand it, at a mediation or arbitration, all the parties could remain in the room at all times. Certainly if there's an arbitration, it's like a trial. So all the parties are going to remain there. Right. That arbitrator is not going to go back and forth and meet, doesn't want to know settlement negotiations. They're just going to act like a judge, and everything's going to be sort of on the record and in full view of everyone. But in a mediation, what are some of the processes that take place?
Well, normally we start the mediation with both parties in the room, the lawyers and their clients. And then you have to really judge what's going on. There are some times when there's such animosity between the two sides that you need to separate them quickly and hold separate caucuses. There are other times where you want to really try to generate some conversation between the parties and get them talking to one another and get them to try to explain to one another what their needs are and what they're looking for and why they have this dispute. And often, after you get them talking, often there's an opportunity now to find some middle ground.
At that point, would you want to meet with them privately, or is that an option just so they can be more honest or candid with you? Or maybe you have a question based on what they said you want to ask them privately to expand on it?
Unless they're so willing at the very onset to settle the case immediately, which is unlikely,
right.
There is a time when, yes, you're going to separate them and we're going to go back and forth between the two sides, try to generate information from them, which you may or may not bring back to the other side. Anytime somebody tells me, well, my bottom line is X, before I will go back and reveal that to the other side, you really have to get the permission of the party telling you that.
You also want to see if they're in striking distance,
yes.
Because it might be they might be far apart and it might be moot, trying to raise it. You have to, as the neutral, do you need to get them into striking distance to reach the next level?
Well, you try,
okay.
It's interesting because often you start a mediation and they're so far apart, you say to yourself that there's no way that they're going to come together. And then when you separate the parties and start talking to them, and then you realize that maybe they're closer than you thought originally.
Or maybe, do you feel you can or should educate them as to reality or what might happen in litigation? Or,
well, that's Elan was talking about this before. There are different kinds of mediation. One's called facilitative, where the mediator feels his or her role is simply to try to get the sides together talking to one another. And another form of mediation is evaluative mediation. And very often, it's not one or the other. Very often, it's a mix of both. And what you're talking about is more in line with evaluative mediation, where you try to tell one side or the other that their expectations are unrealistic, or if they go forward with their case, this is what could happen, and they may want to consider lowering their
expectations. And also after that first round, where you said that you gave an example where they're far apart, that may be where you have to play that, the bad cop and see if you can get them to striking distance, and then you can fine-tune it with them.
Yes.
What are your thoughts, Elan?
Just again, one thing that a lot of people think when they approach both mediation and arbitration is that the positions are going to be debated or they're somehow going to be contended with each other. And To a certain extent, that does happen, especially in more evaluative type mediations. But one of the things that is often very instructive and very useful to the parties is instead of focusing on positions, you instead focus on their needs and interests. And by doing that, you take the entire discussion out of the realm of positional bargaining. And by instead focusing on what they really want to get out of the process and sort of focusing on what they really are driving at.
And there's usually more than money involved with that?
Exactly. And that's
Is there
exactly
an
what we're going to.
apology? Is there some agreement going forward?
It could be there's the more variables you add, the bigger the zone. And that's the point that I want to get across. You could have a case where what's called the ZOPA, the zone of possible agreement, is very, very, very wide.
We only have a moment or two, but is that your role as the media, as the neutral, to figure out, to put that all, congeal that and stir it around and figure out what it's going to take to resolve it, economic and not?
To a certain extent, I view that as being the role of a neutral, but the best way to accomplish that role is to have the parties actually generate those options themselves.
If they can think of them. But if they reach some stumbling blocks or they're stuck on one or two issues, then you're there to help.
Then definitely, yes. You should intercede.
I just want to give each of you 30 seconds to give your tips, your suggestions on mediation, especially commercial mediation. Gary?
Well, I think the most important thing is coming to the mediation with an open view of trying to settle the case, believing that the cases can be settled, and that and instructing their clients and having the right clients there, having the right decision makers there, and instructing those decision makers that this is perhaps a preferable way of dealing with their disagreement than going to court.
Okay, Elan, just less than 30 seconds.
All
sorry.
right, so for all those attorneys out there, I have 3 solid tips for either mediation or arbitration in the commercial context. First is solid preparation. Make sure you know your case and know it cold. Second is emotional inoculation, and that means that in any proceeding involving ADR, you're going to have highly emotional situations, especially where you have issues involving children. It doesn't always happen with commercial, but sometimes happens in other contexts. By anticipating these situations and deciding upon certain coping strategies, both for you and your client in advance, you can certainly facilitate the process. And the last part is issue prioritization. Knowing exactly which issues are more important over other ones will give you tremendous analytical strength and allow you to do a great job.
And just want to add for attorneys to make sure their clients are open to the process. I'd like to thank our listeners. You've been listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College. Please join us next week at this same time for another program on Law You Should Know at ncc.edu/WHPC.
And very quickly, the Nassau County Bar Association has commercial mediation arbitration panels. Please call 516-747-4070 for more information. Thank you very much.